was different. But when the judge compared that with the design patent drawings that Crocs had, he said, the ordinary consumer is going to look at these and think that these are Crocs. And so when there's confusion caused in the marketplace, that's usually an indicator that you're too close to the patent. It's something that's probably getting too close to the line.
Okay. But what if you added something to it that made it look, let's say you added something on top of the shoe? Would that make enough difference for people to say, well, I see that the bottoms look the same, but look at this addition that's added on top of it?
Yeah. And the answer is sometimes. Mm-hmm. There have been a couple of cases where an addition to a product has made it a different product in the eyes of the courts. Usually, though, you have to subtract something to make it a different product. So, for example, one way to look at this is, if I had an iPhone and I added an antenna, would that be allowed?
Right.
And if everything was the same on the phone itself, chances are the courts would say, no, the average consumer is going to say that that's basically an iPhone. You've just added something to it. Mm-hmm. Now, that's not always the case, and so you have to look at the overall impression that the product gives. But generally speaking, if your product has elements A, B, C, and D, and someone else comes along and they can subtract element, say element B, and they're just making A, C, and D, then they have an argument at least that they're getting around your patent. And that question is different based on utility patents and design patents also.
Understood. You have to compare, obviously, to what you're trying to work around, I guess.
Yeah.
Okay. Now, I know that just recently there was a really big court hearing on design patent with Apple and Samsung. Are you familiar with, maybe you can share some of the details of that case with us?
Yeah, and that's an interesting one because Apple had, I forget how many actual design patents that they had on their iPhone and their iPads, but the Samsung the Galaxy Tab and the Galaxy 4G phones were pretty close in terms of appearance, and so it was in large part due to the portfolio of design patents that Apple had that allowed them to win the case. I think they won $500 million from Samsung, and so that it was kind of an interesting case. And the strategy that Apple used was interesting as well. They used in a lot of their applications. They used broken lines around certain things like the control, the on-off switch, or it's not a switch, it's a button, I guess, at the bottom of the phone. They showed that in broken lines. And what that does in a design patent is it tells the patent office that something like a button can go here, but we're not going to require it. Okay, it's an optional feature. And I'll do that a lot with clients if they have something that is, maybe they have 2 or 3 different versions of the product. What we want to show in the design patent is the simplest version, and anything that's optional, like an extra button or an extra antenna or something, we want to show that as a broken line. And but that basically allows the client to sell all 3 versions and be covered by the same patent. But if a competitor comes along and, say, takes the antenna off, you're still left with a design patent that covers the product without the antenna. So it's a tool that they've used. They certainly used it to great effect in this case. And it's kind of interesting if you do some research on design patents. Anytime you see the dotted line, you basically, in your mind, you can just erase it and treat it like it's not there.
Wow. But that's so the lesson there is that you, between the broken lines and also not putting as much on, you want to try to keep it as broad as possible with the option of later on being able to add something instead of having it on and somebody else taking it off.
Right. Now, the flip side to that, of course, is that the more you disclaim from your design, the less you actually have in your design, and the more likely it is that the patent office can find something to use against you. I mean, if you disclaim everything except for, a little piece of, the top left corner, then all the patent office has to do is find something that has a corner that looks like yours. It doesn't even have to be the same type of product, and they can use that against you. So it's a balancing act. You have to be unique and have the three things that are required in a patent: the fact that it's novel and non-obvious and useful, and that you still have to have that. But you don't want to put so much into your drawings that it would be very easy for a competitor to just remove something and get around your patent.
So let's say you file it broadly and they find something. Are you able to then add on top of it with the same application?
Well, you can't add new matter to a patent that's been submitted. So if there was, for example, a dotted line showing, say, the edge of a label, and they found that the patent was that the claim was too broad, that was very similar to a prior art patent that they found, then what you can do is you can convert that broken line to a solid line. But if the broken line wasn't there in the first place, you're out of luck.
Okay.
Generally speaking. Now, there was a case recently where it was I think it was a mouthwash bottle, and it was that exact question. Could they add a line that wasn't there? And it was a very interesting case, but the easiest thing to do is make sure that if you think that there may be a boundary that you need, put it in the patent originally, because it's a big hassle to try to add it after the fact, and you may not be able to.
Very interesting. That's really, and that's why it seems like many people try to do a design patent on their own. But, I mean, it does take some thought process into how to actually file it and the different elements that are needed in it. And, I'm always a big fan of making sure that you get somebody who knows what they're doing, because I want it to be done properly when I submit it. So what typically is a cost of a design patent? And, is it something, Kevin, that I should file it those two different ways at the same time, or do I just file it as without wasting time, to file both of them, or should I just file it broadly in the first place? And if you don't mind telling us roughly what the costs are for putting in a design patent.
Sure. Well, the costs that no one can get around, obviously, are the government filing fees. The small entity, what's called the small entity filing fee for a design patent, is $380, and if you qualify as a micro entity, and I'll explain what that is in a second, then it's half of that. It's $190. So it's relatively inexpensive to file a design patent just from the government fees. Now, it used to be, before March of this year, 2013, there was really only small entities and large entities. And small entities was everyone who had 500 employees or fewer. And so most of my clients were small entities, and all the large entities very often have their own legal staff. So that was a pretty easy question to figure out. It's a question I really didn't even need to ask for most of my clients. Now, as of March, there's a new category called a micro entity. And to qualify for that, it gets a little bit more complicated, of course. The stipulation is that you have to have filed fewer than 5 non-provisional patents in your lifetime for yourself. Okay, so if you're a first-time inventor, that's easy to show. But if you have more than 5 patents in your lifetime, then you're automatically a small entity.
Is it also based on the filing, if you filed a certain amount, or is it actually issued?
Filed.
Okay.
And and provisional patents do not count, and foreign patents do not count.
Okay.
So it's just non-provisional utility and design patents. And the second qualification is that you have to have made less than 3 times the median household income in 2012. And that number equates to $150,162. So if you made less than that amount, gross personal income, people ask me, is it household income? No, it's gross personal income. Then you qualify, and you have fewer than 5 patents in your lifetime, then you qualify as a microentity. and you just have to file it with a certified. You just have to sign a certification form, and then you'll get the 50% discount off of the small entity rates.
Okay.
So that's the fee, and of course, large entities are 2 times 380, so 720.
Okay.
I'm sorry, 760. So that's the filing fee. Now, in terms of what it costs to prepare an application, and with regards to your other question, what's your strategy for filing? Just speaking from our fees, we have a kind of a flat fee schedule. So, most things are just flat fee, which is $895 for what we do. Okay. $895. Now that includes one embodiment, and if you have multiple embodiments or multiple variations, so for example, let's say you have a garment, and the garment is different sizes because you want to go from toddler through adult. And so you're going to have slightly different shapes on that garment, even if it's the same design. Okay, so that's kind of what a different embodiment would be. Now, we don't put dimensions on design patent drawings, or usually utility patent drawings either, because we don't want to lock you into any particular size. But sometimes the shape will be different on different variations or different embodiments. And so if you have multiple embodiments and you have to show, you want to protect all of them, then you have to show all 7 views of each embodiment. And so to do an extra set of drawings for each additional embodiment, there'll be some additional drawing charges for those.
Okay, but that's still in the same design patent filing. It's not multiple
That's right.
patents. Okay.
It's not multiple designs. Now, if you can get away with, let's say you have this optional antenna on a cell phone. One way to show that is to show an embodiment without the antenna and another embodiment with the antenna. But probably the best way is just to show a single embodiment and put the antenna in broken lines. Huh. So it kind of depends on if the variations are mutually exclusive. If they are, like you have different shapes, then you have to actually show the views of each embodiment. Otherwise, you might be able to get away with broken lines, which will reduce your cost, in terms of the drawing charges.
Understood. Okay. Well, that's interesting. So how long does it take for a design patent to get prepared, let's say, or a utility patent? Let's say between a design patent and a utility patent, how long does it take to actually get issued, or possibly like the first office action?
Yeah, well, there's quite a difference. With design patents, you're typically, you're between 6 and 18 months or so. So between half a year and a year and a half. And a year is pretty average with design patents, from when you file it to when you get your first response back from the patent office. And with design patents, typically the first response is a notice of allowance. Now, 95% of the time, that's what we get, is a notice of allowance.
Well, that's if you file it. That's if you file it properly, and you do your,
correct,
your research,
yes.
Right?
And I'll tell you, the patent office examiners in the design art unit, the 2900 art unit, are very good at spotting any discrepancies between your views. So, for example, if you have a top view that shows a certain width, and it doesn't match the front view, they're going to call you on it. And if your drawings are not done properly the first time, it could be fatal to the application. So you definitely want to get someone who is familiar with design patent drawings to do your drawings if you're going to file it yourself. And even then, you'll have discrepancies. You got to be very careful about making sure that all of the views line up. And the views that you need, I mentioned 7 views previously. You need all 6 sides, so front, back, left, right, top, and bottom, and then a perspective view from an angle. Some people call that a 3/4 view. So if you picture a die from a pair of dice, you need all 6 faces, 1 through 6, that show just that side, not any of the other sides, just straight on. Mm-hmm. And then the perspective view would show, say, 3 of the sides.
Got it. Okay. Understood. How long does it take for a utility patent